Professor Porter, criminal law, talking about specifically inchoate crimes and the specific crime of attempt as it relates to certain underlying crimes. Attempt to commit, fill in the blank. So essentially what we're talking about is any substantive crime, including the ones that we studied, the property crimes that we studied, murder that we studied, other substantive crimes. Not only is it a crime to commit murder, it's a crime to attempt to commit murder. Not only is it a crime to commit robbery, it's a crime to attempt to commit robbery. And it falls in line with being a little lesser of an actus rea. It's a substantial step in the direction of a crime, not getting all the way there. So it equates to, and it's like some of the other inchoate crimes that we'll study that'll be subject of different videos. Solicitation, that's the asking another person to commit a crime. Conspiracy, that's the agreeing with someone else, so two or more people that are involved in the crime agreeing to commit a crime is also a crime. Accomplice liability, we're really talking about some sort of orientation in the criminal structure between a principal and an accomplice, someone that's doing the assisting, the encouraging, either before, during, or after, might have accomplice liability and won't be punished as the principal. And that matters in assessing. So we're talking about attempt here. Again, we've talked about it in the overview video having to do with all inchoate offenses. But if you start to think about these things, that maybe there's a little less that happens on the act side. So maybe there's a little more, a little heightened requirement that's on the mens rea side. And as it relates to attempt, what we're talking about is especially there's two varieties of attempt. There's a complete attempt and there's an incomplete attempt. When we're talking about an incomplete attempt, we're talking about taking steps, hopefully a substantial step, more than mere preparation, a substantial step in the direction of completing that crime. So you're not getting all the way there. If you have an attempt to commit robbery, you're taking steps, you're doing things that you would need to do, assuming there's 10 different steps. There's things that you would need to do to accomplish that robbery. Maybe you took certain of those 10 steps, but not all of them. So something lesser on the act side. And so therefore, on the intent side, a little more is required. You have to specifically intend that underlying robbery. You have to specifically intend to accomplish the underlying crime during the steps of the intent. But you also have to knowingly, you have to intentionally act for those steps that you're taking. So kind of a two-part mens rea that's required and a specific intent to commit the underlying crime. Some of the issues that we're going to discuss in our study of attempt, as I mentioned earlier, two different varieties, incomplete versus complete. Incomplete is when you're taking steps towards the direction of completing it, but you don't get all the way there. Can we charge you with attempt as opposed to charging the underlying offense because you didn't complete it? We wouldn't be able to prove as the government completion of the underlying offense. Complete attempts means you did everything, the defendant did everything they could, it just turned out not to equate to a crime. So sometimes when we shoot into shoot at someone and you're intending to kill that person and it turns out to be that the body was already dead. That's a classic example of you did everything you could, you pulled the trigger, you had the requisite mens rea. It just happened to be that you couldn't kill that human being because it was already a dead body. You couldn't rob something you were taking from the store when it turns out it was abandoned property and you couldn't do it, but you had the requisite intent to permanently deprive the owner and you took it and carried it away. It just so happened to not be the property that you thought it would be. So you do everything to the defendant. Those are what's called complete attempts. They both require specific intent to complete the crime, and they both come up short. One comes up short because you're on the path on the way there. The other one comes up short because of something sort of fortuitous, something outside of the defendant's control, means they didn't complete the offense. Separating out the evidence, what does the evidence go to? You're going to need some of this evidence to go to speak to the circumstantial evidence of the specific intent, and you're going to need some of the evidence to show that here are the acts taken, especially in an incomplete attempt. Here are the acts taken that equate to a substantial step. So sometimes evidence can serve both. It can be circumstantial evidence of what's going on in the defendant's brain, the specific intent required to carry out the underlying crime, the intent to commit the underlying robbery, but it also might be evidence of here's some acts that were taken, substantial steps. So making sure that we're analyzing those two legal doctrines, those legal subjects separately, even if evidence may serve to prove both. And factual and legal impossibility. So these has to do with some of the defenses that might happen to complete attempts. So complete attempts, for instance, as we just said, I'm shooting what I think is a human being and I intend to kill that person. Well, when it turns out to be a corpse, the defense might say this is a factual impossibility. It couldn't kill another human being because it was factually impossible to kill another human being. This body was already dead. Well, that's not going to be a defense to a complete attempt. The reason why it was charged with an intent is because the defendant did everything they could, but it turned out that it's an attempt offense instead of a underlying crime. It's not a murder, it's an attempted murder because it was a body, but you still had the requisite intent and you still took a substantial step toward it by pulling the trigger. So even though it was factually impossible, that's not going to be a defense. However, legal impossibility, if the defendant takes certain steps, if the defendant does something, and it just turns out whatever he was doing on that day is legally not a crime. So if it's you can't serve alcohol to a minor and it turns out the person was 19 and that's not defined as a minor in that jurisdiction, well, there you go. He thought he was doing something that was illegal, but it's an illegal impossibility. That can be a defense. So has a defense of impossibility, both factual and legal, relate to attempt crimes, specifically completed attempts. Here's the two ways that you'll see attempt come up in statutes. This is a bank robbery statute from federal law, and you can see the underlying offense, whoever by force and violence, by intimidation, takes from a person. Well, that's bank robbery. This is going to be bank robbery. And you can see in the statute it says whoever takes or attempts to take. So it actually incorporates into the statutory language not only the underlying crime, but any attempt to take the underlying crime. And of course, then there would be further instructions, but also case law that would build out what it means to attempt to take. The other way it comes up, and this is Uniform Code of Military Justice, so this applies to active duty folks. And the Uniform Code of Military Justice is the penal code that governs active duty military. But you can see here, Article 80 applies to all other substantive counts, all of the substantive crimes that are in the chapter. An act done with specific intent to commit an offense. So there you see it's actually defining it the way we're learning it. You have to have a specific intent to commit robbery. You have to have a specific intent to commit battery to be convicted of attempted battery, even though battery is a general intent crime. Ordinarily, you wouldn't need a specific intent to commit battery. And you can see it here, amounting to more than mere preparation. So amounting to more than mere preparation, they're talking about substantial step taken in direction of the crime. Even though failing, so it doesn't get to all the way to the point of commission. So I like this instruction, I like this statute, because not only does it apply to any other statute in the title, but it also is described in such a way that reflects the case law and reflects the black letter law of the way we're learning attempt, that it's more than mere preparation, that it requires specific intent, and it's something that falls short of the ultimate commission of that crime. It really comes down to, especially our incomplete attempts. I think if, which one's more tested? I think the incomplete attempt is more tested, and it's more difficult to work your way through. So, the first part has to do with the two parts of the intent, the specific intent to commit the underlying crime, right? They're going to require that we have that specific intent to commit whatever crime we're attempted. And that could be equal to, but it could be greater than the requirement of the underlying crime itself, like the example I gave of battery before. General intent crime, but if you're attempting to commit battery, it becomes a specific intent crime because you need a specific intent to commit battery during the time of thinking about in the direction of that battery. The second part that you have to wrestle through here has to do with a substantial step to commit that crime. So these are the intentional acts. These are the aggregation of what was it that this person was waking up in the morning and doing that took them from innocently going about their day to taking steps, substantial steps in the direction of committing a crime. And you can see the flip side, the automatic defense argument, the other part of your essay is always going to be, yeah, there's some things that were done. Yeah, there were things that were different in this defendant's day, but it has to be more than mere preparation. If it's just someone that's preparing to do things and thinking about things, they're not going to be charged with attempt. But if it's more than mere preparation, it starts to get into that area of getting to the point of a substantial step in the direction of, so these are intentional acts that it's taken. And I think you just think of this sliding scale of going from 0 to 10 acts that are required to complete the crime. Where along the line at Act 2, at Act 3, at Act 4, where along the line of that sliding scale between intent and acts are we willing to say it's a substantial step? And all those substantial steps were taken with the requisite specific act to commit the crime. So for our intentional, for our incomplete attempts, we're really thinking about what is it that the person did over the course of that time that takes them from 0, from nothing, to the direction of committing this crime, understanding that it doesn't come to fruition, it does not go to completion, but we're willing to say they had specific intent to commit the underlying crime, and here's all the stuff that they did intentionally in the direction of committing the underlying crime.